Different scenario here. A 60-year-old employee of a concrete company is driving from job to job. He decides he wants to stop for coffee, and at his stop for coffee, he's waiting to make his left turn into the coffee shop with his turn signal on, and a car hits him from behind. He's seriously injured, requiring him to be off work for 5 years.
Yep. So first we have a workers' comp claim. He was at his job, he decided to go for coffee. That's a de minimis detour from work. So he's still on the clock, he can absolutely do that. So this would qualify first as a workers' compensation claim.
And he would also have a Social Security claim. So now this person is 60 years old. That puts him in the age category of 60 to 65, which is approaching retirement age. And he's going to be off for 5 years, so he's going to be off at least till he's 65. His full retirement age would be 67. So he would have a very good claim for Social Security disability, and he'd want to get on disability, and then he would stay on disability until his retirement age of 67, and then it would switch over to retirement.
Additionally, you also have a personal injury claim because that person that hit the worker, they were clearly at fault in that scenario, so they're be deemed to be 100% negligent. Even though you can still recover for your medical benefits under the workers' comp claim and your wage loss under that workers' comp claim, and as Lori explained, there's going to be some additional Social Security benefits that you might be entitled to, over this course of time. There's also damages in under either of those scenarios that you might be missing out on. The most common one would be like pain and suffering. In this scenario, you'd be able to recover those excess damages for pain and suffering and anything else that may have been missed under the other claims against that at-fault driver.
But that scenario is slightly different, and the concrete employee makes his left turn directly in front of oncoming traffic, resulting in him being found 100% at fault for the accident.
It's still workers' comp. That's because a minimis detour, that's absolutely fine. You can do that, especially just getting a coffee. And with him being at fault for the accident, again, because he was at work, workers' comp, you do not have to prove negligence. So it would still be a workers' comp claim, even though he was 100% at fault for the accident.
And he would still have a Social Security disability claim.
So if you're going to get in a car accident, be sure you're working when you do it.
Well, good point. So if you are in an accident with workers' comp, yes, you don't need to be negligent, but you don't get the personal injury benefit of pain and suffering. There is no pain and suffering in a workers' compensation claim.
The unfortunate thing about this scenario, you saw both Craig and Lori, they got to raise their signs. In this scenario, while there's no negligence standard in a workers' comp claim, there is a negligence standard in a personal injury case. So you can't say that the other driver did anything wrong in this scenario because the driver making the left-hand turn, us being the worker, they're going to be found liable under Pennsylvania's laws. So in this scenario, unfortunately, while you still, can recover for the medical benefits, the wage loss benefits, you're going to be missing out on the pain and suffering.